for a first appearance. Mr. Rohr, correct me if I'm wrong, but formal charges have not been filed yet?
That's correct, Your Honor. The defendant was arrested. Formal charges have not been filed. By my calculation, I believe it will be due to the court at 3:30 on Monday.
Thank you. Mr. Rohr, anything you would like to say about that?
Not regarding that issue, thank you.
So the court has reviewed a affidavit in support of a warrantless arrest. The court has found probable cause for the arrest. Specifically, I see that Mr. Watts was arrested for 3 counts of first-degree murder.
A courtroom in Weld County, Colorado. The proceeding is brief, procedural, almost mundane in its formality. The judge addresses the matter at hand with the measured precision required by law. Formal charges have not yet been filed. The defendant was arrested on probable cause, 3 counts of first-degree murder. Class 1, felonies. The words hang in the air like a verdict already rendered, but this is just the beginning of a legal process that would conclude with shocking speed. Christopher Lee Watts stands before the court, a man whose name would become synonymous with one of the most disturbing family annihilation cases in modern American history. Within 90 days, he would be sentenced to multiple life terms without the possibility of parole. The case would be closed, the files would be sealed, and the public would move on to the next tragedy. But 8 years later, in 2026, we find ourselves asking a question that refuses to disappear. Was justice truly served, or was it merely expedited? This is not a story about reopening old wounds for the sake of sensationalism. This is an examination of what happens when the machinery of justice moves so quickly that critical evidence is left in its wake. When technological limitations of one era become the capabilities of the next. When a confession, accepted without trial, contradicts itself repeatedly from behind prison walls. When a key witness deletes her entire digital footprint hours before speaking to police, and no one in authority demands to know why. The Chris Watts case was solved in 48 hours and sentenced in 3 months. See, but the questions it generated have persisted for 8 years and counting. If you're drawn to cases where the official narrative doesn't quite align with the documented facts, where the pursuit of truth demands more than a quick resolution, then you're in the right place. Consider subscribing to True Crime Dre, where we examine the stories that demand a second look. And make sure to like this video so we can continue bringing you investigations that go beyond the headlines. Frederick, Colorado, August 13th, 2018. A Monday morning that began with a wellness check and ended with a confession that would dominate news cycles for months. Shanann Watts, 34 years old and 15 weeks pregnant, failed to respond to messages from concerned friends. Her daughters, Bella, age 4, and Celeste, age 3, and were nowhere to be found. The family's suburban home on Saratoga Trail stood silent, its occupants mysteriously absent. By that evening, Christopher Watts would admit to killing his entire family. By Wednesday, he was formally charged. By November, he was sentenced. The timeline from crime to conviction spanned just 93 days, an extraordinarily compressed period for a case involving multiple victims and complex forensic evidence. The Weld County District Attorney's Office processed over 2,000 pages of discovery documents. Police interviewed dozens of witnesses. FBI analysts examined digital devices, vehicle telemetry, and surveillance footage. And yet, for all this apparent thoroughness, the investigation left massive gaps that would only become visible years later when technology advanced and public scrutiny intensified. The prosecution's case rested on a narrative that was, on its surface, devastatingly simple. Christopher Watts had been having an affair. He wanted to start a new life. Rather than pursue divorce, he chose murder. He strangled Shanann in their bedroom after she returned from a business trip. He smothered his daughters. He loaded all 3 bodies into his work truck and drove to a remote oil field site operated by Anadarko Petroleum, where he was employed as an operator. There, he buried Shanann in a shallow grave and disposed of Bella and Celeste's bodies in separate oil tanks. This narrative was supported by Watts's own confession, given to investigators on August 15th after hours of interrogation and a failed polygraph examination. He admitted to the killings. He described the sequence of events. He led police to the bodies. The case, from a prosecutorial standpoint, was airtight. But confession-based convictions, while legally sufficient, are only as reliable as the confessor's consistency and the evidence that corroborates them. And it is here, in the details beneath the confession, that the 2018 investigation begins to fracture under scrutiny. The official timeline presents Christopher Watts's movements on the morning of August 13th as relatively straightforward. Security camera footage from a neighbor's house showed his truck leaving the Saratoga Trail residence at approximately 5:27 a.m. A GPS data from the vehicle's onboard telematics system showed it arriving at the Survey 319 oil and gas site shortly before 7 a.m. This gave investigators a window of roughly 90 minutes, later recalculated to 111 minutes, during which Watts transported the bodies and disposed of them at the remote location. 111 minutes. Less than 2 hours to commit one of the most logistically complex crimes imaginable: to secure 3 bodies in a vehicle without detection, to drive approximately 40 miles through rural Colorado roads, to unload a pregnant woman's body and bury it with sufficient depth to avoid immediate discovery, to hoist 2 small children up an 8-foot ladder to the top of oil tanks, to open the hatches, which required significant physical effort and specific knowledge of the mechanisms, to place each child into separate tanks filled with crude oil, to clean himself sufficiently to report to work later that morning without raising suspicion from co-workers. 111 minutes. The 2018 investigation accepted this timeline as feasible because Christopher Watts confessed that it happened exactly this way. But confessions are narratives, and narratives can omit, compress, or obscure the truth even when the confessor admits guilt. What the 2018 investigators did not have, or did not fully utilize, was the granular telematics data that modern vehicle forensic analysis can now extract. In 2018, GPS tracking provided location pings at intervals to showing where a vehicle was at given points in time. But the internal event logs, door sensor activations, engine diagnostics, and cabin activity markers were either not retrieved or not analyzed with the sophistication available in 2026. Advanced telematics recovery conducted in recent years has revealed something the original investigation missed. During that 111-minute window, the work truck's door sensors registered multiple opening and closing events. More events than would be expected if Christopher Watts was working alone. The passenger side door, which Watts never mentioned using in his confession, showed activation patterns during the period he claimed to be single-handedly managing the disposal process. This does not prove a second person was present. But it does indicate that the vehicle's physical interaction data does not perfectly align with the lone actor narrative that formed the foundation of the 2018 case closure. Christopher Watts's work truck was a 2018 Chevrolet Silverado, standard issue for field operators at Anadarko Petroleum. Like most modern commercial vehicles, it was equipped with a telematics system designed to track location, fuel consumption, engine performance, and driver behavior. These systems generate event logs, time-stamped records of every ignition cycle, door operation, and diagnostic alert. In 2018, investigators pulled GPS coordinate data from the truck to establish Watts's route from his home to the survey site. This data confirmed he made the trip. It provided approximate timing. But the deeper event logs, the ones that record granular mechanical interactions, were not entered into evidence at trial because there was no trial. The plea agreement meant that the evidentiary record was never tested through cross-examination, never subjected to adversarial scrutiny, never forced to answer the hard questions that defense attorneys and forensic experts might have raised. By 2026, vehicle forensic analysis had become significantly more sophisticated. Researchers and independent analysts operating outside the official channels of law enforcement began using publicly available tools to examine what telematics data might reveal about the Watts case. Well, what they found was a pattern of door sensor events that suggested the truck's cabin was accessed multiple times in ways inconsistent with a single person working alone under time pressure. The driver's side door showed expected patterns: open when Watts presumably exited to handle the bodies, closed when he returned to the vehicle. But the passenger side door also showed activation during time periods when, According to Watts's confession, he was physically occupied with burial and disposal activities. Could these activations be explained by accidental bumps, wind, or sensor malfunction? Possibly, but the pattern was consistent, repeated, and occurred at intervals that correspond to periods of activity rather than random environmental interference. This evidence does not conclusively prove anything. But it raises a question that was never asked in 2018. Was Christopher Watts alone during those 111 minutes? The second major gap in the 2018 investigation concerns the digital relationship between Christopher Watts and Nico Kessinger, the woman with whom he was having an affair at the time of the murders. Kessinger worked for Anadarko Petroleum as an environmental consultant. She and Watts met in June of 2018, according to her statements to police. The affair, she claimed, began shortly after their first meeting. She described Watts as charming, attentive, and seemingly separated from his wife. She stated that she had no knowledge of his intent to harm his family, and that she was horrified when she learned of the murders. Nico Kessinger cooperated with law enforcement. She sat for multiple interviews. She turned over her phone. She provided text messages, photographs, and details about her interactions with Watts. Her cooperation was cited by investigators as evidence of her innocence and her status as a deceived party in a tragic situation. But Nico Kessinger also deleted her entire text message and call history with Christopher Watts before contacting the police. This fact is documented in the discovery files released by the Weld County District Attorney's Office. Kessinger admitted to investigators that she erased the messages because she was upset and did not want to see them anymore. She characterized the deletion as an emotional response to discovering that the man she had been sleeping with was a family annihilator. And investigators accepted this explanation. They did not seek to recover the deleted data. They did not treat the deletion as obstruction of justice or evidence tampering. They did not subpoena cloud backups or attempt forensic extraction from her device. Kessinger was never charged with any crime. She was granted immunity, the details of which remain sealed. She later entered a witness protection program and changed her name, effectively disappearing from public scrutiny. For 8 years, this aspect of the case has remained one of its most contentious and unresolved elements. Why would an innocent person delete evidence of communication with a suspect in a triple homicide investigation? What was contained in those messages that Kessinger found so intolerable, she erased them before speaking to authorities? The deletion of text messages is not, in itself, proof of guilt or complicity. People delete messages for many reasons, including emotional distress, privacy concerns, and fear of public exposure. But in the context of a criminal investigation involving multiple deaths, the destruction of evidence by a key witness presents a serious problem for the integrity of the case. In 2018, once data was deleted from a smartphone, it was often considered unrecoverable unless backups existed on cloud servers or the device had not been overwritten. Kessinger's phone, a modern smartphone, likely used encrypted messaging apps and automatic cloud synchronization, but the 2018 investigation did not pursue these recovery avenues aggressively. By 2026, the digital forensic recovery techniques had advanced considerably. Specialized software can now bypass encryption on certain Vault apps, recover fragments of deleted messages from device memory, and reconstruct communication patterns even when the original files have been erased. Independent researchers examining the Watts case have claimed that using these modern tools on archived forensic images of Kessinger's phone could yield significant new information. One specific focus has been on the so-called secret calculator app that Kessinger reportedly used. These apps disguise themselves as functional calculators, but serve as hidden vaults for photos, videos, and messages. Users enter a specific passcode into the calculator interface to access the hidden content. Kessinger's use of such an app was documented in the 2018 investigation, but the contents were not fully recovered because she had deleted the data before turning over the device. In 2026, forensic experts claim that fragments of messages stored in this Vault app have been partially reconstructed. These fragments reportedly contain timestamps and metadata that suggest communication activity on the morning of August 13th, specifically around 6:16 a.m., a time when Christopher Watts was allegedly at the Survey 319 site disposing of bodies. If Kessinger's phone was actively syncing data or receiving messages at 6:16 a.m., And if those messages involved location data or coordination with another device, the implications are profound. It would mean that at the precise moment Watts was committing the most horrific acts of the crime, Nico Kessinger's phone was not silent or inactive. It was engaged. Metadata is the information embedded in digital communications that users rarely see, but that tells the real story of when, where, and how a message was created and transmitted. Every text message, every photo, every app interaction generates metadata, timestamps, GPS coordinates, device identifiers, sync logs. In 2018, investigators had access to some of this metadata, but the analysis was surface level. They confirmed that Kessinger and Watts communicated frequently. They documented the affair. They noted her Google searches, which included queries about Shanann Watts and Amber Frey, the woman who famously cooperated with police in the Scott Peterson case and later wrote a book about her experience. What they did not do, or did not pursue with sufficient depth, was analyze the metadata for patterns that might indicate foreknowledge, planning, or coordination. They did not cross-reference the timing of Kessinger's searches with the timeline of the murders. They did not examine whether her device location data placed her anywhere near the Watts home or the survey site. They treated her as a witness whose testimony needed to be recorded, not as a subject whose digital footprint needed to be forensically deconstructed. This is not to say that Nico Kessinger was involved in the murders. It is to say that the 2018 investigation did not definitively rule out her involvement because it did not employ the tools or ask the questions necessary to do so. By 2026, the questions have only grown louder. One of the most troubling pieces of evidence that has emerged in recent years involves Nico Kessinger's Google search history. According to discovery documents, Kessinger's phone showed searches for Shanann Watts as early as September of 2017, nearly a full year before she claims her affair with Christopher Watts began in June of 2018. This discrepancy was noted by online researchers and independent investigators who gained access to the public portions of the discovery file. If Kessinger was searching for Shanann Watts in September 2017, it suggests she had an interest in Christopher Watts or his family long before the timeline she provided to police. When questioned about this, Kessinger reportedly stated that she may have accidentally clicked on Shanann's Facebook profile while browsing, or that the search was a mistake. Investigators did not challenge this explanation. They did not treat the early searches as evidence of premeditation or planning. They accepted her account and moved on. But Google searches are not accidents in the way that bumping a door sensor might be. They require deliberate input, typing a name into a search bar, selecting a result, navigating to a profile. These are intentional actions, and when they occur months before a relationship allegedly begins, they suggest prior knowledge or interest. But if Nico Kessinger knew who Shanann Watts was in September of 2017, and if she was already researching her online, then the narrative that she was an unsuspecting mistress deceived by a manipulative husband becomes far less credible. This does not mean Kessinger participated in the murders, but it does mean that her role in the events leading up to them may have been more informed and more complex than the 2018 investigation concluded. The physical geography of the crime has also come under renewed scrutiny in 2026. The route from the Watts home on Saratoga Trail to the Cervi 319 site is approximately 40 miles, depending on the exact path taken. The most direct route follows Highway 85 north through rural Weld County, toward a drive that under normal conditions takes around 50 to 60 minutes. Christopher Watts's GPS data from the morning of August 13th shows that his truck traveled this general route, arriving at the oil site within the expected time frame. But recent analysis of the telematics data has identified something the original investigation overlooked: a cluster of GPS pings in a location several miles off the direct route, near a secluded construction area that had no connection to Watts's work duties. These pings show the truck stopping for approximately 4 minutes in this off-route location. The stop was never explained in Watts's confession. It was not mentioned in police interviews. It was not investigated as a potential secondary disposal site or evidence location. The 2018 investigation had a confession, a burial site, and recovered bodies. There was no procedural reason to search additional areas once the primary crime scene had been processed. But if the truck stopped for 4 minutes in a location with no work-related purpose, the question becomes, why? Was this a stop to dispose of additional evidence? To meet another person? To transfer materials between vehicles? Or was it simply a momentary pause that has been overinterpreted by researchers looking for patterns in ambiguous data? Without a search of that location, without soil samples, without a forensic review of what might have been left behind, the answer remains unknown. And it will remain unknown unless the case is reopened and modern investigative resources are applied to questions that were never asked in 2018. Yet one of the most significant developments in the 2026 push to re-examine the Watts case involves a legal mechanism known as Rule 35C, a provision under Colorado law that allows for post-conviction relief in cases where new evidence or constitutional violations can be demonstrated. Christopher Watts's current legal representatives have reportedly filed motions under this rule, arguing that the original 2018 investigation was constitutionally inadequate due to ineffective assistance of counsel and the failure to fully investigate exculpatory or complicating evidence. The argument is not that Christopher Watts is innocent. He confessed. He pled guilty. He is serving multiple life sentences without the possibility of parole. The argument is that the full truth of what happened on August 13, 2018, was never pursued because the legal process prioritized speed and certainty over completeness. Specifically, the Rule 35C petition argues that Watts's defense attorneys failed to challenge Nico Kessinger's credibility, failed to subpoena her deleted communications, failed to demand forensic analysis of her device location data, and failed to cross-examine her regarding the discrepancies in her timeline. Because Watts accepted a plea deal, none of these issues were litigated in court. No jury heard testimony about the September 2017 searches. No expert witness explained what the 6:16 a.m. metadata sync might indicate. No forensic analyst testified about the unexplained GPS stop. And the plea deal closed the case, but it also closed the door on a full accounting of the evidence. Public interest in the Watts case has not diminished in the 8 years since the murders. If anything, it has intensified as more information has become available through Freedom of Information Act requests, independent research, and the release of partial discovery files. Online communities dedicated to analyzing the case have grown into the thousands. Documentaries, podcasts, and YouTube channels have dissected every available piece of evidence. Petitions demanding the unsealing of Nico Kessinger's immunity agreement have gathered tens of thousands of signatures. This sustained attention is not driven by ghoulish curiosity. It is driven by the perception that the official narrative is incomplete, and that critical questions were never answered, that a key witness was shielded from scrutiny for reasons that have never been publicly explained. Why was Nico Kessinger granted immunity so quickly? What did she provide in exchange for that immunity? Why were her contradictory statements about when she first became aware of Shanann Watts not treated as impeaching her credibility? Why was she allowed to delete evidence and then disappear into witness protection without facing any legal consequences? These are not speculative questions. They are based on documented facts from the discovery file, from police interviews, and from publicly available records, and they remain unanswered. The 2018 investigation into the Watts family murders was conducted under enormous pressure. The community was traumatized. The media was relentless. The evidence of Christopher Watts's guilt was overwhelming. Law enforcement and prosecutors did what they believed was necessary to bring the case to a just conclusion as quickly as possible, sparing the surviving family members the agony of a prolonged trial and preventing the defendant from using the legal process to further torment those who loved Shanann, Bella, and Celeste. But justice is not only about securing a conviction. It is about ensuring that every relevant fact is examined, every witness is held accountable, and every piece of evidence is tested. When a case is closed through a plea deal, these safeguards are bypassed. The truth that emerges is the truth that the defendant chooses to tell, filtered through his motivations, his fears, and his desire to protect himself or others. So Christopher Watts has changed his story multiple times since entering prison. In letters, in interviews, in statements to investigators, he has offered conflicting accounts of how and why the murders occurred. If the person who confessed cannot maintain a consistent narrative, how can the official record be considered complete? The technology available in 2026 allows for a level of forensic analysis that was simply not possible 8 years ago. Vehicle telematics can be extracted and interpreted with precision. Deleted digital communications can be recovered from devices and cloud servers. GPS and cellular location data can be cross-referenced to create minute-by-minute reconstructions of movements and interactions. If these tools had been applied in 2018, the case might have looked very different. If they are applied now, in 2026, they might reveal a version of events that is more complicated, more disturbing, and more complete than the one we have been told. This is not about exonerating Christopher Watts. He is guilty. He admitted his guilt. The evidence against him is insurmountable. But guilt in a criminal case is not a binary state where one person is responsible and all others are absolved. Crimes, especially crimes of this magnitude, often involve networks of influence, enablement, and knowledge that extend beyond the person who physically commits the act. The question is not whether Christopher Watts killed his family. The question is whether he did so entirely alone, without foreknowledge or assistance from anyone else. And whether the investigation in 2018 was thorough enough to answer that question definitively. 8 years later, the evidence suggests it was not. The door sensor data from the work truck suggests the possibility of another person present during the disposal. The metadata from Nico Kessinger's phone suggests communication activity at the exact time Watts was at the crime scene. The September 2017 Google searches suggest prior interest in Shanann Watts that contradicts Kessinger's stated timeline. The unexplained GPS stop suggests a detour that was never investigated. The deletion of text messages suggests a desire to hide something that investigators never demanded to see. None of these facts, taken individually, prove conspiracy or complicity, but, taken together, they form a pattern of unanswered questions that a complete investigation would have addressed. The families of Shanann, Bella, and Celeste Watts deserve more than a fast conviction. They deserve the whole truth. They deserve to know whether the person who destroyed their loved ones acted alone or whether others knew, helped, or encouraged what happened on August 13, 2018. The criminal justice system is designed to uncover truth through adversarial process. Prosecution and defense test each other's evidence. Witnesses are cross-examined. Experts are challenged. Juries weigh credibility. But when a case is resolved through a plea deal, this process is short-circuited. The truth that emerges is only as complete as the confession given and the investigation conducted. In the Watts case, the confession has proven unreliable. The investigation, thorough by the standards of 2018, has been revealed as incomplete by the capabilities of 2026. Technology has given us the tools to answer questions that were left unasked. Public pressure has created the momentum to demand that those tools be used. Legal mechanisms exist to reopen cases when new evidence or constitutional deficiencies can be shown. The question now is whether the system will act, whether the sealed immunity agreements will be unsealed, whether the deleted data will be recovered and analyzed, whether the unexplained GPS stop will be investigated, whether Nico Kessinger will be required to answer, under oath and subject to cross-examination, the questions that were never asked in 2018. The Chris Watts case is not closed. It has never been closed. It was paused, suspended, placed in a file, and marked resolved. But resolution is not the same as truth, and a guilty plea is not the same as a complete accounting. If this examination has raised questions you believe need answers, make sure to like this video and subscribe to True Crime Doctrine. This channel is dedicated to cases where the official story is only the beginning, where the pursuit of truth requires looking beyond the headlines and into the evidence that was left behind. Share this video with anyone who believes that justice demands more than convenience, and stay tuned for Part 2, where the evidence becomes even more difficult to ignore. The truth is not always fast, but it is always worth pursuing. The geographic path that Christopher Watts traveled on the morning of August 13, 2018, has been documented through GPS data pulled from his work truck. The route from his home on Saratoga Trail to the Survey 319 oil site is roughly 40 miles, a drive that should take approximately 50 to 60 minutes under normal circumstances. The GPS logs from that morning confirm that Watts made this journey within the expected time frame, arriving at the site before 7 a.m. But within that general route, there exists a specific anomaly that was never explained, never investigated, and never reconciled with the timeline presented in court. A cluster of GPS coordinates shows the truck stopping at a location several miles off the direct path to the oil field. The stop lasted approximately 4 minutes, and the location had no connection to Anadarko Petroleum work sites, no connection to any known associates of Watts, and no connection to any legitimate reason for a detour during what was allegedly one of the most time-sensitive and logistically complex crimes imaginable. In 2018, investigators had the GPS data showing this stop, but they did not pursue it. They had a confession. They had bodies. They had a defendant who was willing to plead guilty. There was no procedural incentive to investigate a 4-minute stop at an unexplained location when the primary crime scene had already been processed and the perpetrator had admitted guilt. But the existence of that stop raises a question that has only grown more urgent as new analysis has been applied to the data. What happened during those 4 minutes? Was this a pause to dispose of additional evidence? Was it a meeting point with another individual? Was it a location where materials or information were exchanged? Or was it simply a momentary stop that has been overanalyzed by researchers looking for patterns in ambiguous data? The location itself is near a construction area that was active in the summer of 2018. Satellite imagery from that period, recently enhanced through modern image processing techniques, shows the presence of multiple vehicles in the vicinity during the early morning hours of August 13th. One vehicle visible in the imagery matches the general make and model of a car owned by an associate of Christopher Watts at the time. This does not prove that the vehicle belonged to that associate. It does not prove that anyone other than Watts was present at the location. But it does establish that the area was not deserted and that other vehicles were in proximity to the spot where Watts's truck stopped for 4 minutes during the most critical window of the crime timeline. This is not speculation. It is a documented discrepancy between the route Watts described in his confession and the route his vehicle actually traveled according to GPS records, and it was never addressed in the 2018 investigation. The physical evidence recovered from the Survey 319 site in August 2018 included the bodies of Shanann, Bella, and Celeste Watts, as well as soil samples, debris from the shallow grave, and photographic documentation of the oil tank hatches where the children's bodies were found. The recovery operation was conducted under extreme conditions. The oil tanks were active, filled with crude oil, and required specialized equipment to safely extract the remains. The focus was on recovery, identification, and preservation of the bodies for autopsy. It was not on microscopic trace evidence that might have been left on the hatches, the ladder, or the surrounding infrastructure. By 2026, forensic science has advanced to the point where touch DNA, the genetic material left behind by skin cells when a person handles an object, can be recovered and analyzed even from surfaces that have been exposed to harsh environmental conditions. This technology was not widely available or standardized in 2018, and it was not applied to the Watts case during the initial investigation. If the oil tank hatches were handled by more than one person, if the ladder was climbed by someone other than Christopher Watts, if any part of the disposal process involved assistance from another individual, touch DNA analysis conducted today could potentially reveal that. The hatches on the oil tanks are heavy, requiring significant physical strength and familiarity with the mechanisms to open. Christopher Watts was trained as an oil field operator and would have known how to access the tanks. But the question of whether he could have done so alone, under time pressure, while managing the bodies of 2 small children, has been raised by forensic experts who have reviewed the case details. The 2018 investigation accepted Watts's account that he acted alone because he confessed to acting alone. But confessions describe what the confessor wants to be believed, not necessarily what occurred. If physical evidence exists that contradicts the lone actor narrative, it has never been tested because the case was closed before those tests became standard practice. One of the most persistent technical questions surrounding the Watts case involves the digital infrastructure of the household. Shanann and Christopher Watts lived in a modern suburban home equipped with wireless internet, smart devices, and multiple personal electronics. Both used smartphones extensively. Both had social media accounts, messaging apps, and cloud-connected services. The FBI seized these devices during the investigation and conducted forensic analysis to recover text messages, photos, and browsing history. But forensic analysis of home network data conducted in the years following the conviction has identified something unusual. The router in the Watts home recorded encrypted data handshakes during the early morning hours of August 13th that do not correspond to any of the devices that were seized by investigators. A data handshake is a technical term for the communication exchange that occurs when a device connects to a network. Every device has a unique identifier, and when it connects to a router, that connection is logged. The logs from the Watts home router show connections from devices that were known and accounted for, such as Shanann's phone, Chris's phone, and various household electronics. But they also show connections from at least one device that was never identified or recovered. And this has led to what researchers and analysts refer to as the second phone theory, the possibility that Christopher Watts, or someone else in the household, was using a device that was not disclosed to investigators and was not included in the evidence presented during the plea process. The existence of such a device would have significant implications. It would suggest deliberate efforts to conceal communications. It would indicate premeditation and planning beyond what was acknowledged in Watts's confession. And it would raise the possibility that communications were occurring with individuals outside the household during the time period when the murders were being committed. In 2018, the technology to decrypt and trace these network handshakes to specific devices or manufacturers was limited. By 2026, signal reconstruction and network forensic analysis have advanced to the point where investigators can potentially identify the type of device, the operating system, and even the apps that were active during the mysterious connections. If a second phone existed, and if it was used to coordinate, communicate, or document the events of August 13th, that information is now potentially recoverable from the archived network logs. The relationship between Christopher Watts and Nico Kessinger has been examined extensively, but primarily through the lens of the text messages and phone records that were recovered in 2018. Those records showed frequent communication, romantic and sexual content, and evidence of an affair that began in June of 2018. But those records were incomplete because Nico Kessinger deleted her text message and call history with Christopher Watts before turning over her phone to investigators. What was not fully explored in 2018 was the content and context of the communications that occurred during the critical days immediately before the murders. The secret calculator app that Kessinger used to hide photos and messages was documented, but the contents were not fully recovered because she had erased them before providing the device to law enforcement. Forensic experts working with modern data recovery tools have claimed that fragments of these deleted communications have been partially reconstructed from device memory, and that the content suggests a level of operational detail inconsistent with casual romantic conversation. Specifically, there are indications of messages that reference timing, logistics, and planning. Not explicit admissions of involvement in murder, but language that suggests coordination around schedules, locations, and actions. This does not constitute proof of conspiracy, but it does constitute evidence that the nature of the relationship between Watts and Kessinger may have been more complex and more directly connected to the events of August 13th than the 2018 investigation concluded. The deleted communications also reportedly include exchanges that occurred during the 111-minute window on the morning of the murders. If Kessinger was communicating with Watts, or with a device associated with Watts, during the time he was disposing of bodies, the innocent bystander narrative becomes untenable. One of the most controversial aspects of the Watts case is the legal treatment of Nico Kessinger. In 2018, she was interviewed multiple times by law enforcement. She provided statements, turned over her phone, and cooperated with the investigation. In exchange, she was granted immunity from prosecution. The exact terms of that immunity agreement have never been publicly disclosed. The agreement remains sealed under court order, and Kessinger has never been required to testify in open court or face cross-examination by defense attorneys because there was no trial. By 2020, Kessinger had changed her name and entered a form of witness protection, effectively disappearing from public view. This has fueled widespread speculation and criticism, not because immunity agreements are inherently improper, but because the discrepancies in Kessinger's statements and the evidence gaps surrounding her involvement were never tested in an adversarial legal process. The discovery files show that Kessinger was conducting Google searches related to Shanann Watts as early as September 2017, nearly a year before she claimed the affair began. She also searched for terms including "Can police trace deleted text messages?" and Amber Frey, the woman who cooperated with police in the Scott Peterson case, and later published a book about her experience. These searches occurred before the bodies were discovered, suggesting that Kessinger was aware, at minimum, that she might become a subject of law enforcement interest and was taking steps to understand the legal and media implications. And this does not prove that Kessinger participated in or had foreknowledge of the murders, but it does suggest a level of awareness and self-protective behavior that is inconsistent with the narrative of a shocked and grieving girlfriend who simply wanted to help the police find the truth. In 2026, legal advocates and victim family members have called for the unsealing of Kessinger's immunity agreement and any subsequent statements she may have provided to law enforcement in exchange for her continued protected status. The argument is that immunity should not be used to shield witnesses from accountability when their statements contain material inconsistencies and their actions suggest possible involvement beyond what they have publicly acknowledged. The question of Nico Kessinger's physical location on the morning of August 13, 2018, has been a subject of intense scrutiny. In her statements to police, Kessinger said she was at her own residence that morning and had no contact with Christopher Watts until later in the day. However, cell phone location data, which places devices based on their connections to cellular towers, has reportedly shown activity on Kessinger's phone that is inconsistent with her stated location. Specifically, analysts examining the case have pointed to a 6:16 a.m. timestamp when Kessinger's phone allegedly pinged off a tower with coverage areas that include parts of Frederick, the town where the Watts family lived and where the crime occurred. If accurate, this would mean that Kessinger's phone was not where she said she was at a critical moment in the timeline. Cell tower data is not GPS. It does not provide exact coordinates. A phone pinging off a particular tower means only that the phone was within the coverage area of that tower, which can span several miles depending on geography and tower placement. It is possible for a phone to ping off a tower that covers a location where the phone is not actually present due to signal routing and network load balancing. But when tower data is cross-referenced with other location indicators, such as Wi-Fi connections and app-based location services, a more precise picture can emerge. In 2018, this level of cross-referencing was not conducted or was not presented as part of the case against Christopher Watts. But by 2026, advocates for case reopening have argued that modern location forensics could definitively establish where Kessinger's phone was during the morning of August 13th and whether her stated alibi is consistent with the digital evidence. If the evidence shows that her phone was in or near Frederick during the time the murders were occurring or the bodies were being disposed of, it would represent a fundamental contradiction of her official account and would justify a thorough reinvestigation of her role. The legal mechanism that is most frequently cited in calls to reopen the Watts case is Colorado Rule of Criminal Procedure 35C, and which allows for post-conviction relief when new evidence is discovered that could not have been presented at trial or when constitutional violations affected the fairness of the proceedings. In the Watts case, there was no trial, so the standard is somewhat different. The argument is not that evidence was improperly excluded from a trial, but that the plea process was fundamentally incomplete because critical evidence was never fully investigated. The specific claims center on ineffective assistance of counsel. The argument that Christopher Watts's defense attorneys failed to adequately investigate and challenge evidence that might have revealed the involvement of other parties or mitigating circumstances. Because Watts accepted a plea deal, his attorneys did not subpoena Nico Kessinger for deposition. I did not demand forensic recovery of her deleted communications, did not cross-reference her phone location data with the crime timeline, and did not challenge the immunity agreement that shielded her from prosecution. These failures, the argument goes, deprived Watts of a full and fair legal process and deprived the victims' families of a complete accounting of how and why the murders occurred. A Rule 35C petition does not seek to overturn a conviction or release a prisoner. It seeks to reopen the evidentiary record to allow new information to be considered. If granted, it would allow for the subpoena of witnesses, the forensic re-examination of digital and physical evidence, and potentially the unsealing of documents that were kept confidential during the original investigation. As of 2026, and it is reported that such a petition has been filed or is in preparation, though the details and status of that filing are not fully public. If the petition is granted, it would mark the first formal reopening of the Watts case since the 2018 plea deal. Public interest in the Watts case has not diminished with time. If anything, it has intensified as more details have emerged through Freedom of Information Act requests, independent research, and the release of partial discovery files. Online communities dedicated to analyzing the case have grown into the tens of thousands. Documentaries have been produced. Podcasts have devoted hundreds of hours to examining the evidence. YouTube channels have dissected every available piece of information. This sustained attention is not primarily driven by morbid curiosity. Though that element certainly exists, it is driven by the perception that the official narrative is incomplete and that key questions were never answered. Why did Nicole Kessinger delete her communications with Christopher Watts before speaking to police? Why was she granted immunity so quickly? Why were her contradictory statements about when she first became aware of Shanann Watts not treated as impeaching her credibility? Why was the GPS detour never investigated? Why were the oil tank hatches never tested for touch DNA? Why was the second phone theory never pursued? These are not speculative questions invented by conspiracy theorists. They are based on documented facts from the discovery file, from police interviews, and from publicly available records, and they remain unanswered. The families of Shanann, Bella, Nia, and Celeste Watts deserve answers to these questions. They deserve to know whether Christopher Watts acted entirely alone or whether others had knowledge, provided assistance, or bore responsibility for creating the circumstances that led to the murders. They deserve to know whether the legal system prioritized a fast resolution over a complete investigation. And they deserve to know whether the person who Christopher Watts killed his family to be with was truly an innocent victim or something more complicated. The role of immunity agreements in criminal investigations is a necessary and often appropriate tool. Prosecutors offer immunity to witnesses in exchange for testimony or information that helps secure convictions against more culpable defendants. This is standard practice and serves important law enforcement purposes. But immunity is not a shield against scrutiny. It is not a license to provide incomplete or contradictory information without consequence. And it should not be used to prevent a full accounting of the facts when significant evidence suggests that the immunized witness may have had a more substantial role than was initially understood. In the Watts case, Nicole Kessinger was granted immunity in 2018 based on the understanding that she was a cooperative witness who had been deceived by Christopher Watts and who had no knowledge of or involvement in the murders. But the evidence that has emerged since that time, including the September 2017 Google searches, the deleted text messages, the cell tower location data, and the fragments of tactical communications recovered from the calculator app, suggests that the initial understanding may have been incomplete. If Kessinger knew more than she disclosed, if she was in contact with Watts during the critical hours of the crime, if her phone was in Frederick when she said she was elsewhere, then the immunity agreement was based on a false premise. And if that is the case, the agreement should be revisited, the terms should be disclosed, and Kessinger should be required to provide a full and truthful account under oath and subject to cross-examination. This is not about vilifying a witness. It is about ensuring that the legal process serves truth and justice, not expediency and closure. The digital evidence in the Watts case is vast, but it is also incomplete. Text messages were deleted, apps were erased, devices were sanitized before being turned over to investigators. Network logs were not fully analyzed. GPS data was not cross-referenced with cell tower pings and app-based location services. The secret calculator Vault app was documented but not fully recovered. By 2026, the technology exists to fill many of these gaps. Deleted messages can be recovered from device memory and cloud backups. Network logs can be decrypted and analyzed to identify unknown devices. GPS and cell tower data can be integrated with app location services to create precise timelines. Vault apps can be bypassed using specialized forensic tools. If these technologies had been available and fully utilized in 2018, the case might have looked very different. If they are applied now, they might reveal a version of events that is more complicated, more disturbing, and more complete than the one we have been told. The question is whether the legal system will allow that to happen, whether the sealed documents will be unsealed, whether the immunized witness will be required to answer the hard questions, whether the GPS detour will be investigated, whether the touch DNA will be tested, whether the second phone will be identified. The families of the victims deserve these answers. The public, which has followed this case with sustained attention for 8 years, deserves these answers. And the integrity of the criminal justice system, which depends on the principle that truth matters more than convenience, demands these answers. Christopher Watts is guilty. That is not in dispute. He confessed. He pled guilty. He is serving multiple life sentences without the possibility of parole. But he will never be released. He will die in prison. But his guilt does not answer every question. It does not explain every discrepancy. And it does not absolve the legal system of the responsibility to ensure that every person who played a role, however small, in the events that led to the deaths of Shanann, Bella, and Celeste Watts is held accountable. Justice is not only about punishing the person who commits the physical act, it is about understanding how that act became possible, who enabled it, who knew about it, and who might have prevented it. It is about ensuring that the truth, however uncomfortable, is fully revealed and fully acknowledged. The 2018 investigation into the Watts family murders was conducted under enormous pressure and with the best intentions. But it was incomplete. It left questions unanswered. It accepted explanations that have since been contradicted by new evidence. It granted immunity to a witness whose statements have proven inconsistent. And it closed the case before the full truth could be established. 8 years later, the tools exist to finish what was left undone. The question is whether the system will use them. The legacy of the Chris Watts case is not only the horror of the crime itself, but the questions that remain about how thoroughly it was investigated and how completely the truth was pursued. For the families of the victims, for the community of Frederick, for the millions of people who have followed this case with sustained attention, those questions matter. They matter because truth matters, because accountability matters, and because the integrity of the justice system depends on the principle that every case, no matter how quickly resolved, must be fully and fairly investigated. In 2026, we have the technology, the evidence, and the legal mechanisms to reopen the Watts case and answer the questions that were left unanswered in 2018. Whether that will happen depends on the willingness of prosecutors, judges, and law enforcement to prioritize truth over convenience and completeness over closure. The families of Shanann, Bella, and Celeste Watts deserve nothing less. If this examination has raised questions you believe need answers, if you think that justice requires more than a fast conviction, then make sure to like this video and subscribe to True Crime Dre. This channel is dedicated to cases where the official story is only the beginning, where the evidence demands a second look, and where the pursuit of truth is never finished. Share this video with anyone who believes that accountability should extend to everyone involved, not just the person who confessed. The truth belongs to the victims, and until every question is answered, the case is not closed.